Hello, my name is Zachary Smith, and I'm an attorney at Beresford Booth, and I'm here to talk about the benefits and the pitfalls that can be avoided by formalizing rental agreements. Why would you formalize a rental agreement? First, it protects the relationship by setting clear expectations. It lets each party, the renter and the landlord, know where they stand and what consequences and conditions may come to pass throughout the rental relationship. This is really important to do even when the relationship pre-exists the renter tenant, the renting tenant and landlord relationship. For example, having a family member reside in a property that you may own, or letting a friend stay for a little while. But all of those things are very typical and common, but it's really important and smart and prudent to protect those relationships by not leaving things simply to verbal agreements or unsaid completely, such as misunderstandings about what is owed or when it is owed. And it really will help in the future if the dispute rises to some kind of legal level. Having the document in place that has been signed by both parties offers a bunch of protections to each side. And it provides a measure of financial security for both the tenant in the sense that they won't get hit with any unexpected costs or fees or amounts, and the landlord can count on the monthly payments being made based on the terms of the agreement. And another one is a contingency style protection, which is what happens if the renting agreement is for 6 months, but the person that is renting needs an extra month, then the agreement should call out any increase in rent or time frame or expectations that way. So it can protect the landlord and the tenant in situations where the agreement, the period of time governed by the agreement has come to pass. The foundations for a good agreement. These are just a handful of things that are extremely necessary and very prudent to include, which is the names of all the parties involved. For example, you don't want to have unnamed, or excuse me, a subletter who is living in the property who is not named in the agreement. Plus, you want the property's address and description. You want to have the expectations and timing of when rent is owed, how much is owed, the method for conveying the payment, and any kind of increase for late rental payments. How long the lease will be for, if it's a fixed term, like 1 year or 2 years, or if it's something that is subjective, like I know my renter needs to live here for 5 months and they want the 6 month to be an option. The security deposit, that should definitely be collected at the execution of the document. It doesn't do the landlord any good to put a big fancy provision in there for a security deposit if the tenant never pays it and has lived there for several months. There's almost no motivation for the tenant to provide the security deposit at a later date. It also should include who is responsible for what: repairs, maintenance, upkeep. Maybe the landlord is responsible for the appliances, but the tenant is responsible for yard work. And then, of course, sometimes rental situations need to end prior to the rental agreement. And a good rental agreement will have a provision or a section that describes the ways that a tenant may leave early. Sometimes that is the obligation of the tenant to continue paying until the landlord finds a suitable replacement, or sometimes it's a flat style fee amount where it's a month and a half to terminate early, something like that. Possible problems that you can run into when you don't have an agreement. Maybe it's your sister's best friend and she moves in and you guys just never get around to formalizing the agreement. Well, these kind of things can happen. Suppose that friend stays for a long time. We're talking more than a couple of years or some substantial amount of time. And they don't have an agreement in place and they start to feel like they are entitled to some legal ownership in the property. You want to avoid claims of tenancy in common where any person that moves into your property can then file a lawsuit and bring you into court saying they own part of your land. This is avoided by having a very specific clause that states that this is a renting tenant landlord relationship. It does not amount to co-ownership, and it never will amount to co-ownership. Another problem you can run into is staying beyond the rental term or not paying rent on time. When a tenant doesn't leave after a lease ends, but doesn't have any interest in renewing and otherwise doesn't want to deal with the fact that their agreement is up, that is why it's prudent for the landlord to include those kind of contingencies in the agreement. Common solution to this problem is that once the lease term is up, there is an agreed upon rent increase for each month beyond the rental agreement, such as month to month is one common phrase that's used to describe this style of agreement, where the lease term is for a year and it's at rent of $1,000. But when the year is up, if the tenant does not want to leave but doesn't want to renew, maybe the rent increases to $1,400 a month or something like that. Some amount that is clearly set out at the beginning of the relationship to avoid a situation where the tenant remains but doesn't have any guidance on how to pay, and the landlord doesn't have anything in the agreement that they can point to. It's also prudent to lay out what happens in a situation where the tenant stays but doesn't pay, regardless of month-to-month provision, which is a clear outlined process for the options and rights the landlord has when a tenant stays and doesn't pay. Basically, an eviction clause. Some additional problems are maintenance and repairs. Oftentimes, people live in apartments, houses, rental properties, whatever. The wear and tear that is normal and expected, that might be something that the tenant expects the landlord to pay for. And the landlord may look at something that is broken or has stopped working or become ineffective and may not believe that it has broken down because of normal wear and tear. The way to avoid this kind of a problem where there is something broken that needs to be fixed and no party feels it's their responsibility is to clearly line this up in the agreement. A very common typical solution to this is a walk-through inspection that's conducted by both the landlord and the tenant. Oftentimes, it can be done together, and the tenant just goes through the house or apartment and marks on a list everything that she sees or he sees from the beginning of their tenancy, which is to say that this was broken already or this was already in a declined state. I do not want to be told when I move out that this was my fault. And this is especially important to do at the beginning before occupancy is taken, because how is a landlord supposed to know after several weeks or months whether the damage is new or not? So the move-in, move-out inspection checklist is extremely important. And it's also prudent for the landlord to require payment of a security deposit prior to move-in. It doesn't, like we said a minute ago, it's very hard for a landlord to convince a tenant that they should come up with a security deposit once they've already been living in the property. Another slice of problems that we can deal with are verbal agreements and misunderstandings. When an agreement for occupancy between a landlord and tenant, when there is a pre-existing friendship, relationship, acquaintance, those are the kind of things that lead a landlord to think, no, I don't need to reduce this to writing. My friend vouched for this person, or it's my sister, or it's my cousin. Those are subject, like our memories, to changing over time. Verbal agreements are very hard to enforce. Each party may remember it differently or may intentionally omit something that they remember if it's in their favor to do so. And this can result in disparate lens that the agreement is being viewed through, where the tenant thinks the agreement is X and the landlord thinks the agreement is Y. The way to avoid this is just to reduce all these agreements to writing. And another thing is you can go on the internet and you may be able to find all manner of standardized rental agreements. They're Rocket Lawyer or whatever, all over the internet. There you'll find examples. These are a good data point as a place to start, but you really want to tailor them as a landlord to your needs and expectations. And if you're a tenant, you need to make sure that you're reading through what you're about to agree to before. This is something that a lawyer can help with, and certainly Beresford Booth can help with. Once the document is agreed upon, both parties sign it, and each party needs to keep a copy for their records. That will help avoid situations where one party misremembers and also doesn't have the hard document to fall back on. Keeping copies in both parties' possession will ensure that everyone honors the agreement. Holdover tenants. We've addressed this a moment or two throughout this conversation, and the holdover tenants are people that are renting tenants who stay beyond the lease term. We've talked about a couple of the solutions, increasing rent once the lease term is over, or having a clear eviction outline process in place. Either way, these provisions need to be included at the beginning before anyone moves into a property to avoid having nebulous gray areas where the tenant believes their rights are X and the landlord believes their rights are Y. When a lease term ends, you want the lease agreement to specifically state what the options are. Increased rent, certain amount of time, and then outlining how the landlord may go retaking possession of the property, the eviction process. This is similar to month-to-month leases. Once a year-long lease or 6-month lease may end, if the tenant needs a little bit longer to establish their next place, you want to make sure that the renting agreement has clear expectations and obligations of the parties for what happens when a tenant wants to have the ability to leave, such as 30-day notice to the landlord and some kind of increase for the premium of being able to leave whenever you want. And then, of course, early termination. Maybe tenant has a job opportunity that they need to be in another city. Well, it's really important for the landlord to have clear guidance in the rental agreement for when a tenant wants to break the lease, whether or not they owe for a certain amount of time, how much they owe, the ways that the tenant can reduce the costs that they owe, such as possibly finding a replacement to take over the lease, or maybe the landlord doesn't want to deal with that and they don't mind fixing the place up and getting it ready for relisting. Then they just want to say, okay, well, if you're leaving early, I'm not going to get the benefit of the remaining 6 months of this lease agreement. That's fair, but I do think that the tenant should pay me at least 1.5 months rent to be able to break early. Whatever the landlord feels and whatever the tenant agrees to, it just needs to go in the agreement when the relationship starts. The standard rental agreements we spoke about a moment ago that you may find all over the internet, these are not perfect because they are exactly what they're purport to be. They are boilerplate starting documents. They are very general in nature. They don't contemplate family dynamics. They don't contemplate situations where you as a landlord may want to give your tenant a little bit of grace because of the relationship that pre-existed the renting tenant relationship. And the standard agreements don't often consider all the things a landlord or tenant may want to consider, such as holdover tenancies, month-to-month tenancies, late fees, early termination. These kind of things are the easy to prevent problems on the front end by putting them in your agreement that can save you lots of time, money, and upset on the back end when they come to pass, or if they come to pass. Feel free to contact Beresford Booth to ensure that the agreement you're about to sign or that you're about to offer to a tenant as a landlord has the provisions and contingent considerations that you want it to. You do not want to be faced with some unique risk that you didn't think of because you pulled a document off the internet. That concludes today's webinar. Thank you for your time. Feel free to contact me at the information provided if you have any further questions or agreement that you would like someone to take a look at with you. Otherwise, we will see you next week.